Our keynote speaker will be live streamed on our homepage so that you can encourage your friends to also take part if they can't be here. If you've registered for a workshop, your itinerary will be found in the back of your name tag. And we'll end the workshop portion of the day with a poster session and happy hour in the Munnerlyn atrium. Also, there will be staff throughout the day in the Eisenberg Rotunda who can help you with any logistical questions. Well, it's really wonderful to see so many faculty, staff, students, alumni, and community members here today. Your presence here shows us that you place a value and importance on diversity and inclusiveness, and that you're willing to engage with others and be open to new ideas. That openness will truly make it possible to use this crossroads as an opportunity for progress. The workshops and posters that you experience today will explore where we are as a university with respect to race, power, and even defining diversity. These can be difficult subjects, but that is the essence of why we need this event, so that we can engage with others who have a spectrum of ideas and backgrounds that may be different from our own in respectful dialogue through which we hope to find common ground, acceptance of others, and hopefully celebration of our differences. Our office strives to bridge the silos of our university and community and support and showcase the great work that is being done here. This conference would not be possible without the efforts of our entire community and the support of our leadership. Let me take a moment to thank our Board of Trustees, two of whom have taken time out from their busy lives to join us today, our deans, and especially our president, whose commitment to diversity has been clear throughout his tenure here. So without further ado, I'd like to welcome our President, Joel Seligman, to the podium so that he can introduce our keynote speaker, Lee Bollinger.
I want to just start by particularly thanking Vivian Lewis for her leadership of our diversity and inclusiveness efforts over the last several years, and especially for having orchestrated these conferences year after year. This is our biggest conference ever. There'll be over 500 registrants, 18 workshops, 21 remarkable posters, the involvement of our entire university community. Please join me in a round of applause for a great leader. Now, President Lee Bollinger is extraordinarily accomplished figure in American law and American academic administration. His achievements are broader than his efforts in race relations and diversity, with which I'll mostly introduce him. But just so people appreciate how extraordinary his accomplishments have been. Since he began his career at Michigan Law School in 1973, he early established a reputation in freedom of speech, freedom of the press, with books such as The Tolerant Society, Images of a Free Press, which perhaps were as important as any other works in this domain. He is someone who's speaking on this topic some years ago at Washington University inspired me to begin my side job, occasionally teaching undergraduates in a constitutional law seminar. He frames and articulates issues not just in terms of legal concepts, but in terms of policy implications. And this is a dimension of his life and career which is now transcending national borders when he focuses on free speech in a global society. It is a truly important intellectual contribution. As Dean of Michigan Law School, as Provost at Dartmouth, President of Michigan University of Michigan, and now Columbia University, Lee has been one of the great figures in academic administration. His legacy, which hopefully will only be computed many years from now at Columbia University, will include a dramatic expansion of the size of the campus, the quality of students and faculty. It's not irrelevant, the most successful capital campaign in the history of Columbia University, the rejuvenation of an endowment which will provide resources for centuries to come. But what we're addressing today is probably the topic area about which Lee is best known throughout the country. And this is the topic of race and the topic particularly of certain constitutional law decisions which bear his name, Gruder versus Bollinger, Gratz versus Bollinger. There are many cases, those not familiar with the law understand, are essentially bilateral engagements. One person sues another person, or one person sues one institution. It's quiet, it's not in the headlines, it involves a couple of lawyers, a judge. That is not the kind of litigation that we are concerned with today. This is social impact litigation. And Lee's ability in the Gruder and Gratz case to change the nature of the dialogue about the Supreme Court's review of what we refer to now as diversity in higher education was not inevitable, was not easy, and was one of the great legal achievements in the period after Brown versus Board of Education. In an earlier and terribly important case called Bakke versus Regents of the University of California, Justice Powell, in a concurring opinion which was treated like a majority opinion, basically said that one cannot take race and implicitly gender into account in higher education admissions standards to achieve most of what reasonable people might regard as the basic reasons for doing it, such as racial balancing, such as trying to parallel the population of the nation, the state, the profession. One could, however, take into account race to achieve diversity, by which he meant it could be a plus factor, as long as it was not given legal significance through separate committees and separate scoring systems and so on. This limited and confined our ability to develop the concept, and it placed institutions that engaged in diversity always on the defensive. They appeared to be giving a preference to some where the underlying social policy could not be discussed or articulated. After the Bakke case, there was a decision called Adirondack, which did not deal with higher education, but construction under federal agencies, in which, in effect, we were told that race no longer could be taken into account. And it was a significant backdrop to the litigation that was mounted against the undergraduate program at the University of Michigan and the law school at the University of Michigan. Lee had two connections to this litigation. As dean of the University of Michigan, he had asked a committee, which included Rick Lempert, a very talented professor, Ted Shaw, who later became the leader of what's called the Inc. Fund, the NAACP Legal Defense Fund, a few others on the faculty, to prepare a report putting into writing the policy of the University of Michigan Law School. It was carefully crafted so that there would be no separate committees or separate scoring. It was consistent with Bakke in terms of articulating the need for race and gender to be plus factors, and there were others. It emphasized review of the whole file. I was a member of that wonderful faculty, and my memory, and Lee's, I'm not sure, is quite the same, is that the faculty discussed this report for 4 minutes. We adopted it because it seemed the most obvious thing in the world. It was a codification of the existing law. It was a unanimous adoption. Unfortunately, or perhaps fortunately, there were challenges to the standard that ultimately winded their way up through the district court and the federal court of appeals to the Supreme Court. Lee's finest hour came later as university president in the end game of this litigation, where he was able, in successive order, to orchestrate support from the Board of Regents for what was terribly expensive and controversial litigation, where he was able to assemble perhaps the single most impressive collection of friends of the court to write briefs or otherwise urge the incredible significance of diversity in our society. And these began with former President Gerald Ford and many, many others. It involved working with the lawyers. It involved choosing the right lawyer for the case. And it resulted in the case that for many years now has allowed us to continue to take race and gender and other plus factors into account in admissions and other decisions in higher education. These cases were won by a thread, and we live at a time when subsequent challenges, most recently a case called Fisher versus the University of Texas, make clear that the inevitability, the endurance of these standards is by no means certain. No one has spoken more eloquently and more thoughtfully, both on the defense of the existing standards and on the broader social issues than Lee. So it is my great honor to introduce to you, perhaps as important a speaker as we've ever had grace this podium, to address an issue which matters to all of us, diversity at our university and nationally. And I do so just with a final point at a moment that's particularly charged. I suspect almost all of you saw the Democrat and Chronicle 2 days ago, whose headline reads, "Report, New York schools the most racially segregated." And this refers through K through 12. I suspect almost all of you are aware of the Community Foundation report on the poverty in inner city Rochester. These are issues which were not solved with Brown versus Board of Education, although it was an absolutely essential step forward. The protection of human rights, which is what this is really about, is a topic on which we must be eternally vigilant. And I now welcome to our podium a man who wrote a book called Eternal Vigilance, Lee Bollinger.
Thanks so much, Joel. Thank you very, very much, Joel, and thank all of you for coming today. I think a conference like this is critically important. We had these at Michigan. I know that they had a profound effect on the development of a sense of culture around diversity, and I want to congratulate Vivian and all of her colleagues for this event. Thank you again for inviting me. I want to say just a word about Joel. I was on the faculty when Joel was appointed. This was one of the great appointments that the law school made. Joel's incredibly smart. He actually knows something. You know, most law professors over the past 25, 30 years moved into a state where you just thought important things, and it didn't matter so much. In fact, it might even get in the way if you knew something about the law. And Joel was just unquestionably the expert in securities law. and corporate law in America and abroad. And so it was, it was a real delight to have somebody, who had knowledge as well as a credible mind. And of course, he's so gracious and so warm and so forthcoming, and I'm sure in this campus and in this community and beyond, all of those qualities, you're the beneficiaries of it. You've got a great president. What I would like to do is I'm going to go back over, in my own way, the jurisprudence that Joel also introduced. I don't think you can go over this too many times, and I know that there are many young people here for whom some of these cases may seem like very ancient and perhaps even forgotten events in the history of this country. So as I have lived this world of race, civil rights, affirmative action, higher education, America, as I've lived this now for many decades, one of the things that's striking to me is how much people are forgetting and how problematic that is for the topic we're discussing today. So I want to go back and try to convey what I think was the societal reasons, the thinking, the mentality, the sensibilities for why we have the policies today and why they're still so important. One of my deepest concerns, and I will close with this point at the end, one of my deepest concerns is that diversity as a value is being emptied of passion, of meaning. And that's very bad for what it is we're trying to do and very bad for the policy at a time, especially when there are many people who have made it their life mission to abolish the policy. So if we're going to defend the policy, and that's the way democracy works, if we're going to defend the policy, we have to have arguments, we have to have reasons, we have to have a philosophy. And I want to make the point both, I want to make the point that the philosophy exists, that it's still relevant, and that it's not being made with the force that I think it should today. So the first thing I'm going to do is take you through the cases, the jurisprudence, but the surrounding sensibilities are equally important. And then I want to talk about a few of the arguments that are made today against affirmative action, and I want to address them as effectively as I can. And then I just want to close with, again, this observation that what we're talking about goes to the heart of the values and ideals of America. And unless we can reconnect those two things, our policy and our deepest values and ideals, we're going to lose what everybody in this room views as one of the great achievements of America. And other people around the world view America as having this great achievement too, and what a pity it would be if at the same time most all of the world is struggling with the very same issues of discrimination against groups and how to be inclusive and how to change over time. And we've done so well, what a pity it would be in this new world of globalization if we lost that leadership. Okay, so that's the context for speaking to you today. And I don't have a prepared speech, I don't have a written, I have notes that I may refer to, but this is something that I have thought about again and again, year after year, and so I just want to speak to you about it. So in my view, it all begins with Brown. Brown versus Board of Education, 1954. We're celebrating a half century after Brown. And That decision, of course, said that states could not officially tell black children they could not attend white schools. I was born in 1946. My wife was born in 1946. This is within our lifetime. This is not something that goes way back to the 19th century. These are laws that told families that they were inferior and could not send their children to the same schools as other people. And the Supreme Court unanimously struck that down. Now, there's a view today that's very much at play in the affirmative action debate. Justice Roberts, Chief Justice Roberts, holds this view, that Brown versus Board of Education was really only about that, stopping discrimination based on race. That is not my view, and it's not the view held by many people. The other view is that Brown versus Board of Education was about racial justice. It was about the need to overcome centuries of enslavement of African Americans and some other groups, but principally African Americans, slavery, overcoming the injustices of slavery, and a century of Jim Crow laws, of official acts of segregation and discrimination, and to achieve an integrated society. Not just to end what was there and leave it for everything to work out as it might in the market, but to do things as a society that would result in justice or integration or equality in meaningful ways. So there's a big debate about that starts with Brown and what's the meaning in this society of that, both as a matter of constitutional law and how do we understand the 14th Amendment, but also a matter of policy and culture and the values of the country. Debate, that's what it is right there. From my point of view, and I think Joel's and everybody else who was in law in the 1960s and 70s, which is when I went to law school and then became a law professor, and I was part of that group of people who saw the civil rights movement, who saw the anti-war movement, who saw the environmental movement, who saw the feminist movement, who saw the efforts to try to take our criminal law process and make it fair and more just in all kinds of ways. A right to a lawyer, you couldn't just be prosecuted by the state and not have the right to a lawyer if you couldn't afford one, and questions of interrogation. And I mean, there were countless questions that were all refracted through the U.S. Constitution during the 1950s and 60s, and it was exciting to be part of it. And it was the result of Brown. Brown stood for a principle that the law, and especially the Constitution, could be a way to achieve a better, more just society. Not only about race, but about many other things, some of them deeply affected by race. My field is freedom of speech and press, as Joel said. It is absolutely clear, and it was noted by one of the first great First Amendment scholars, Harry Calvin, that the development of freedom of speech and press that we know today is the result of cases that were decided by the Supreme Court in the 1950s and 60s, mostly the 60s, that involved civil rights issues and shaped free speech and free press because of that context. So we have the most protective system of freedom of speech and press in the world today and in history. I don't think there has ever been a society that has more protection for freedom of speech and press than the United States does today. Almost all of that starts in the 1960s. That's the foundation. New York Times versus Sullivan, Brandenburg, Cohen versus California. These are all the great names, Pentagon Papers. And many of those cases were came out the way they did because of issues of civil rights in America. New York Times versus Sullivan. Just now, the 50th anniversary, in fact, a week ago, said an official can't sue a newspaper for a falsehood about them that hurts their reputation unless they can show actual malice, knowledge, or reckless disregard of the truth. That case, the facts of the case, involved an advertisement in the New York Times that appealed for support to help the civil rights movement in Alabama, where the allegations were that the police and state police and local police were harassing and improperly arresting Martin Luther King. And that case, New York Times versus Sullivan, was about race. So my big point here is we got Brown versus Board of Education, a momentous event in the history of this country. It was about race. It was about discrimination, but it was also about integration. And it was more than that. It was about justice in America, about making us live up to our ideals, and that shaped the next 25 years in ways that we are still living with today. In the late 1960s and 70s, the society became somewhat frustrated, I think, with the efforts to desegregate and to integrate. Busing became highly controversial. There were many other things. The society was changing. But there was still an enormous amount of effort to realize the dream of Brown. One of the things that happened in the late 60s and 70s was that universities across the United States said, especially law schools and medical schools, and to some extent then undergraduates, universities said, we really need to make special efforts to include African Americans, Hispanic, Latino, Native Americans in our student bodies. We need to reach out and be more inclusive. And if that means adjusting our standards, it's worth it for the good of the society. We're producing leaders, we're producing people who are going to go on in society and need to be able to understand each other across boundaries. And we as a society have work to do on correcting the injustices of the past. Affirmative action was born in that period. There are many people in this room who, like me, went to undergraduate, you went to college, maybe, or law school, maybe there was one African American in the class, and maybe 10 women in a class in a law school. By the time I started teaching in 1973, in that period, with affirmative, pretty soon you had 10% of your entering class would be African American, 20% would be women, and that has grown. So that today, in today's world, the result of affirmative action, but not only, we have student bodies that are 50% women and 20% underrepresented minorities, maybe 30% underrepresented minorities. We love this. I believe students come to Columbia because it is one of the most diverse student bodies on all counts in the country. I bet you say the same thing. If you ask students, why did you come here? One of the things they will say is because of the diversity. They have come to value it. It seems natural. So universities adopted this in the late 60s and 70s. And that was important. Very big step. And it happened all across the country, not just some universities, not just public and not private. It was basically 100% effectively. In the late 70s, a movement began that would challenge this affirmative action in universities, in state institutions, as unconstitutional. And the argument was, you are taking race into account. The 14th Amendment says you cannot use race as a factor in public decision-making. Brown versus Board of Education upheld that. You have to have the most compelling state interest to ever take race into account. And here you are, state institutions, University of California, Davis, picking your medical students by asking what's their race and giving a plus factor, giving a benefit to African Americans just because they're African American. And that's unconstitutional. And it went to the Supreme Court, and that's the Bakke case. And the court was badly split. And Justice Powell, who was the swing vote at the time, the Kennedy vote today, wrote an opinion, and he said, I think this is constitutional. Here's what's not constitutional. And Davis, you fall on this score. You can't have quotas, by which we mean you can't just say 10% of our class or whatever percentage is going to be filled no matter what the qualifications of the people. You can't just fill up your 10% in that way. You also cannot take race into account in order to correct past injustices based on race in the society. So I'll come back to this. This is a big, big, big point in my view. You cannot say we want to take race into account because the society has been unjust towards African Americans, and we're going to correct that by including them. You can't do that. What you can do is take race into account for educational purposes for diversity. You can have diversity for educational purposes. And that's kind of all there is to the opinion. It's not like it goes on to explain, well, what is educational purposes, what does that mean exactly? But you kind of got a framework there. And the important thing was that it was the fifth vote, and therefore it allowed affirmative action to continue, and everybody continued. I became dean of the University of Michigan Law School in 1987. As Joel said, at that time, with the Reagan administration, we were beginning to get hints, more than hints, that the Justice Department and the Department of Education were investigating universities and their affirmative action policies. We wanted to make sure that our policy was legal. We set up this committee that Joel referred to, and they came back and said, we believe in taking race into account as a factor in admissions for educational purposes. It gave some examples, and that's basically what it said. At the time, the undergraduate, or later, actually, I don't know when it precisely came up, the undergraduate at Michigan, also seeking diversity, had a different approach, and they used points. So they had what was famously known as a grid. And the grid would allocate points based upon things in your application. So if you were sports, you got points. If you got 3.8, you got this many points. If you came from Michigan, you got this many points. And if you were African American, you got these points. And that's the way they did it, a point system. Now, of course, they're big, huge number of applications, and the law school is much smaller, much more intimate. So we passed, these were the policies, and at Michigan, as here, diversity was a very big theme of the university, public institution in Michigan. Given the people who were there, this was a deep value. In the 1990s, the group, the Center for Individual Rights, began really coming after institutions for challenging affirmative action. And they first went to the University of Texas Law School and challenged their affirmative action policy. I was an expert witness in that case, testifying as to the value, the virtues, the benefits of racial diversity for a law school education. It's called the Hopwood case. It's a little complicated case because they did something which later was regarded as, and is today regarded as, a very bad thing to do and dangerous, and that is to take all the African American, Hispanic, Native American files and have them go before a separate committee. So there was a two-track process in the application system, in the admission system. And so that made them vulnerable, in addition to just a straight challenge that you can't take race into account even for educational purposes. It went to the Fifth Circuit, which is the Federal Court of Appeals that oversees that area of the country. Texas is included. And to the shock of everybody who was paying attention to this, the Fifth Circuit held that affirmative action, even for educational purposes, violated the 14th Amendment. So that was a big victory for the opponents, and it was scary for the higher education community. That was followed by Proposition 209 in California, a ballot initiative to amend the Constitution, forbidding the Cal system to take race into account for affirmative action purposes. And that passed and is in effect today. Even though there are efforts to undo it, it's still very much in effect. And the state of Washington had a referendum too, and that passed. And I became president of the University of Michigan in 1997. And I'm told right away, you have two very big problems we anticipate. The first is we're going to be investigated for improper booster activities of the Fab Five basketball team. And that turned out to be the case, and I spent the next 2 years sort of working on that. And the other thing is the Center for Individual Rights is coming after you next. And they want to get to the Supreme Court, and they believe Michigan, for all the things I've said, is the great case that they can make their points. And there was a professor in the university, a philosophy professor, who had gotten hold of the grid that I mentioned before. So the Center for Individual Rights got two plaintiffs, one from the undergraduate who had been rejected, one from the law school who had been rejected, and those were the plaintiffs. They were the legal team, and with the grid, they sued. And there was a front page article in the New York Times about this suit, and the grid was right there. If you got a 4-point, you get these points. If you're African American, you get these points. And given Hopwood, Proposition 209, the mood in the country, Washington State, this was not a favorable moment for defending affirmative action. It really was a time that looked like the tide was turning against it. And there were many, many people who urged me as president, you got to settle this, you got to get out of this, this is a disgrace to the university, a disgrace to the higher education system, and It was my decision, and I said, we are going to defend this, and we're going to defend it fully and vigorously, and we're going to take it to the Supreme Court if we have to. Other people, the regents, the faculty, the students, there was, I believe, a strong, strong consensus within the institution to do this. Now, you have to be very careful when something like this is a major social policy question. I understand there are different points of view about affirmative action. I mean, I am, as you can tell, an advocate about this, but there are other points of view that are against it that are entirely reasonable. There are people who believe, and I respect this, that you cannot survive with the principle of Brown versus Board of Education if you say you cannot take race into account as a public institution, government, whatever, unless you do it for good purposes. And then what are good purposes? If we really want to stop racism in America and the infection of our public policies, you have to have a clean 100% rule that you can never take race into account. Okay, that's a powerful argument. And there are other powerful arguments. And we have to, if we believe differently, rebut them. And if we can't rebut them, then we have to change our minds. Okay, this is a hard problem. And in a university, that's more complicated because we have to have debate about these things. We have to make space for debate. So one of the first things I did was to say, I'm out of the debate in the university about affirmative action. Somebody else is going to be responsible for setting up debates and inviting speakers and doing all of this, because I am viewed as now an advocate, and people will be suspicious of what decisions are made and so on. So you have to preserve that space for real debate about these things. Nevertheless, we were sued. I was sued personally. The university was sued institutionally. Others were sued individually. We're going to defend this, and we're going to make the case, and this is a fight. Now, there were several things that I felt had to happen for this case. We hired very good lawyers. These are the things I felt were critical. One is that we had to refer to Brown. The more we argued about Bakke, and nobody really understands Bakke, but everybody understands Brown versus Board of Education and what it means. So this case was about Brown. It was about achieving integration for the society, improving inclusiveness, getting the benefits of all the talents of America. It was realizing the dream of Brown. That's going to be the theme. Then we had to show that this is not just a University of Michigan case. It's a university case all across the country. As I said, all universities have policies of affirmative action. And furthermore, it can't just be a university case, it has to be an American case. Since Brown versus Board of Education, every institution in the society, corporations, nonprofits, foundations, media, everybody works on being more inclusive. That's the greatness of Brown. Now, we have a long ways to go, but we're in a lot better shape because a lot of institutions and organizations and people in America have worked on this after Brown. And we have to make the point that if you attack the University of Michigan and undermine that policy, you are effectively undermining it all across universities in America and every place else. This is the beginning of the unraveling of the dream of Brown. That had to be the theme. The problem is implementing that. One of the things I've learned is that when you're a defendant in a lawsuit, nobody wants to join you in that mission. They don't know what really may be involved, their counsel will say, stay as far away from them as you can. And really say things like, they do that, we don't do that, sort of thing. And even universities that, I had conversations with university presidents that were shocking to me. Not wanting to be part of a large group that would say, as goes Michigan and their policies, so goes our institution. But in the end, it worked, and the AAU came forward, and it was very strong, representing the great research universities in the country. But how do you go beyond that? I tried to get political figures, politicians, to say things in support of affirmative action, and to my fascination and regret, nobody would do so. And it remains to this day, I am sad to say, something that most people in political life will not touch. They will not come out strongly in support of affirmative action. I'll come back to that. So the breakthrough on that was that Gerald Ford is a graduate of the University of Michigan. And I had gotten to know him through that. And I called him and I asked him, would he write an op-ed supporting the university's policies of affirmative action? And he said yes. And he wrote an op-ed that appeared in the New York Times. And the op-ed said the following. When I was a student at the University of Michigan, he said, I played on the football team, played center. And when a university from Georgia came to Michigan to play, Michigan had one black player. And the Georgia team said they would not take the field if that black player were on the field. And to our disgrace, we did not allow that black player to play, and the game went ahead. And to this day, I regret that that happened. But that's what's happened all across America, and we still have much healing to do in our family. And it was a stunning thing for him to say and to do. And I continue to this day to admire Jerry Ford for many reasons, but that's the biggest. That then unlocked corporations. So we went to General Motors, they agreed, Steelcase, and by the end of that effort we had 50, I can't remember exactly the number, but several dozen major corporations saying, without affirmative action in universities, we are not going to have the people to hire who are capable of working in diverse environments, and we need that, and please uphold this. And then I was having lunch with David Halberstam, who said, have you ever thought about the military academies? And I know a man, a wonderful man, last name was Cannon, who was chief of staff in Gerald Ford's administration. And he sits on the Naval Academy board, and I believe they practice affirmative action because you need a diverse officer corps for a diverse military. And it makes sense. I met with Cannon, and he worked on this, and we've got retired generals that came forward and said, don't you dare touch affirmative action because it will affect the national security interests, the defense interests of America. And many people think that brief in particular was the difference for Justice Sandra Day O'Connor when we ultimately won in the Gruder case. So that was really a very big effort. The other thing I decided was not to make this just a law case, but to make it a public discussion case. Very easy when you're in litigation. All lawyers will say to you, do not say anything in public about the case while it's in litigation, because anything you say will be picked up and used by the other side against you. And I said, that's just not going to work. I mean, this is as much about public understanding and debate as it is about law and legal case and winning, and we've got to do both. And we decided we would take this all the way to the Supreme Court if necessary. We won in the Gruder case. The grid case was struck down as unconstitutional. The law school policy was upheld. The vote was 5-4. Sandra Day O'Connor wrote the key opinion. This was a major victory. The first clear, strong statement of constitutional support for affirmative action in higher education. Since Gruder, things have been moving along. Justice Department, Education Department came out with very strong statements interpreting Gruder and recommending taking account of race in admissions and education. Universities continue strongly, I think, to support affirmative action and practice it. But there also have been problems. So one of the problems are state referendum ballot initiatives, and now in a number of states, 6 I think, affirmative action has been banned in universities. One of them was Michigan. After we won, the state had a referendum to ban taking account of race in admissions, a little more general than that, but that's basically it. And it passed by a vote of 58-42. That is now being challenged this moment in the Supreme Court as unconstitutional. It's called the Schuette case. If I have time, I may say something about that. But the other major case, which happened just about a year ago now, was the Fisher case. And Fisher involved, that's also before the Supreme Court, that involved what the University of Texas had done after the Hopwood case, but before the Gruder case. So remember, in the Hopwood case, the Fifth Circuit struck down their policy of affirmative action. Afterwards, wanting affirmative action so much, wanting diversity so much, the state passed a law saying that 10% of all high school students, every high school in the state, would have automatic admission to the university. Because, sadly, the state has a de facto segregated system, that will give you diversity. It's one of these ironies of life. They then, after the Gruder case, added on top of that diversity a Gruder-like take race into account as a factor. It was a complicated system, not one with the 10% solution, as it's called, with the Gruder on top, not one practiced by other universities. It was challenged, went to the Supreme Court, and again, I think the Fisher case is best read as an affirmation of Gruder. It certainly upheld, took Gruder for granted as good. But there is a tone to the opinion which suggests that universities may have to submit more proof that there are not other ways that they can get diversity than by taking race into account. And we're still in the process of figuring out just how big a burden that is going to be on affirmative action. So that's where we are. Let me turn to the arguments. There are just 2 or 3 I want to focus on. One is an argument that we don't need affirmative action any longer. We don't need it because we're in the post-racial period of America. We have a president who is African American. We have an attorney general who is African American. Doesn't that symbolize that race no longer really is a salient factor in American life? Joel referred to this UCLA report about New York State being increasingly segregated for its K-12 education system. It's more segregated today than in 1960. That's true of Detroit. It's true all across the country. 1/3 of African American children attend basically all black schools. Half of white children attend basically all white schools. At our K through 12 level, it is really distressing to see the very little progress, in a sense, that has been made on the issue of just the fact of segregation for our children. I could go on other statistics about how race matters in America still, how there is discrimination, how there is injustice and the like. I'm going to leave that just where it is, and we can come back to it. I think it's indisputable. The other argument is there are other ways that you can adopt to also accomplish diversity, racial and ethnic diversity, without taking race into account. And you should do those, because it would be better for everybody if you did. The first one is, forget about considering race, take financial need into account, because we have a big problem of class in our society. There are many people who come from low-income families, and they don't know about this. They don't have good guidance counselors. They don't have people to help them prepare admissions letters. They just can't get into the system, even though they're every bit as talented as the middle class and upper class children. So take financial need, low income status into account, and one of the other benefits you'll accomplish something that's good in itself, but that will also bring you racial and ethnic diversity, and you won't even have to have it as a factor. Well, a lot of scholarship has been done on this, and for reasons just having to do with population statistics, the fact is, if you don't know anything about the race of an applicant except the fact that they come from a low-income background, you're much more likely to admit another white student than you are an African-American student or Hispanic. So it simply doesn't work to get racial and ethnic diversity by only focusing on financial need. That said, we should do both. I mean, every university, I think, Columbia certainly does this, I'm sure UR does this. We want kids from low-income families. We believe in that too. And it's just important, though, not to be deluded by the idea that there is this other simple means of getting racial and ethnic diversity. Then there's an argument that we should maybe have some affirmative action, but the way it's structured now, it produces a very bad result. African American students, Hispanics, Native Americans are admitted to schools for which they're not as qualified. That's them making the argument. It's called the mismatch thesis. And it would be better than if they went to a lower tier, lower reputation place where they would, their numbers, their scores and everything would predict that they would do better. And that would be better for everybody, because then they'd be happier and they'd do better in life, and we'd get more engineers and math people, and we need more engineers and math people, and a whole set of arguments like that. Well, there's a lot of debate about the data that are being used to support the underlying thesis. If we stopped practicing affirmative action, taking race into account admissions, and students just went to a lower tier school, would they actually do better in life? I think most of the credible data says no evidence of that at all, or it's actually not right. The better the school you go to, the more income you're going to make over the course of your life, including for African Americans, Hispanic, Native Americans. That's now being established, I think it's fair to say. I'm going to put that kind of argument aside. What did the data really say? I love the statement that General Powell made, who was very supportive in the Gruder, Michigan cases when I talked to him. When this argument came up, he said on a radio show, I think if this really idea is that it hurts me to go to a better school where I might not do quite as well as if I went to a lower quality school, I think I'd rather take the extra income I'd make at the better school and hire a psychologist to help me with that problem. So I think that's my preference. What I say is, first of all, the differences. I mean, all these students who are admitted, taking race into account today, at any university, whatever the level, are incredibly talented people. At Columbia, you look at who's admitted, and this is the very top 1%, 2%, 3% of all people taking. You look here, it's the same thing. I mean, the differences, we let in children of alumni, give them a boost. We let in athletes. I got a boost, I'm sure, coming from Oregon. I mean, nobody goes to New York from Oregon. And so when I was at the University of Oregon, I know Columbia gave me a pretty big boost to get somebody from Oregon. I mean, they don't even know how to pronounce Oregon. I mean, it's usually pronounced Oregon. So I'm sure that I mean, lots of people get benefits and a plus factor in. So, I mean, let's be serious about, is this really damaging to people? And the last thing is, my view is, let people decide. I mean, we all live a life where we say, I want to do the best I can. If this opportunity is before me, and maybe I'm not going to do quite as well as there if I go someplace, almost all of us are going to take that bigger opportunity and the challenge. And why not let African Americans, Hispanic, Native Americans make that decision for themselves? The last argument that's made that you don't need affirmative action anymore is, don't worry, if the Supreme Court strikes it down, changes its mind, overrules Gruder, you can just cheat. And you can get affirmative action. And so what you should do is, in the admissions process, you don't have to know the race, ethnicity of an applicant. You know their zip codes. You know whether they're coming from the inner city of X. You know whether they're this. You'll just figure out ways to get a diverse student body, and everything will go on, and we'll all be happy, and we won't have affirmative action policy, but we'll still get the benefits of diversity, et cetera. And I've always felt this is one of these subterranean kind of thoughts that people have, even people very supportive of affirmative action. Just don't worry so much about it. What's the big deal? We'll figure out. We're all so committed to it. And my view is it just will never work, and it shouldn't work. It won't work because there are people there ready to sue, and when you get in a lawsuit, you have to turn over everything you've got, all your emails, all your conversations, everything, and somebody's going to have said, we need more diversity, let's go to that zip code. And the court's going to say, you just violated the Constitution of the United States as we interpreted it, and you have disgraced yourself in higher education, and you have violated a fundamental law of the United States, and that's terrible. So everything is at stake here. If you believe in diversity, this is the only way to get it, and it's a great system because it's worked so well, and it's the right system given where we come from. Last argument I mentioned here is universities really are doing a bad thing because it's too late to help people and really should do it in K through 12. That argument, I think, has always been, great, let's do it in K through 12 too, and we're just doing our part, and it works and it matters and it's not everything, but we shouldn't do nothing because we can't do everything. The last thing I want to say is the biggest problem I see is going back to Brown. It's the It's the disappearance, the gradual disappearance, it's Brown and all the sensibilities of what we're trying to do and need to do as a society dissolving into the past. And we're left with this kind of, we do diversity for educational benefits, but we don't really go very far in saying much more than that, when we should be saying race still matters in America. Our system is unjust to this day. We have not fixed the problems that Brown identified. We have not built a fair and just society. A colleague of mine, wonderful colleague, Ira Katz-Nelson, published a book a couple of years ago called When Affirmative Action Was White. And it's all about the policies around 1940s when veterans were coming home, the war was over, college tuition programs were supported for veterans. They did not help African American students in the way that they helped white students. When the federal mortgage assistance programs were set up, and that did not allow African Americans to buy houses, to get equity, to hand on to their children in the same ways that it allowed white people to do, program after program, very important, valuable programs that transformed America into a broad middle, upper middle income country, did not benefit blacks. And when you think about the accumulated effects and benefits of that, and when you add in a system where your educational opportunities as a child are affected by many things, but one of them happens to be the property tax base of your district, because our desire for local control, a perfectly valid idea, is the foundation of it is a property tax system for supporting the cost of providing education. If you put all these things together, we are a society that is every bit as much in need of all the things that we worked on coming out of Brown, and we need to continue to do so today. And affirmative action in universities is just a small but very important piece of this. And it was a pity in Brown in Bakke when Justice Powell, for reasons that nobody knows, but when he said, you cannot have affirmative action, you cannot take race into account if you're trying to correct past practices, bad practices, injustices, but you can do it for educational benefit by severing the argument about the past and the context. My view is that has gradually neutered the very reason why we need to do this. Now, there are very, very important positive benefits to diversity. It's not all about injustice. I understand that. We have different peoples, different cultures, different backgrounds, different life experiences, everything. It is thrilling when you're in an environment where those differences are maximized and shared and exchanged and so. Yes, diversity is a very meaningful experience, life experience, but so is, and it's not, indeed it is connected, but so is the fact that we have so much injustice left to work on in this country. A way to close, to put this, is we need a new civil rights movement in America. We need something that puts all this together far better than I have and says, civil rights is not over, that movement. Indeed, it needs a whole fresh start. It needs to take what we have and to move it into the 21st century, but it needs a movement. I say this not with false modesty. I should not be the person who is among the leaders on this issue. I am a believer in this. I have been part of it. I've worked on it. This will be something that I will regard as one of the great privileges of my life. But I am an academic leader. I am not part of a civil rights movement. I'd be part of it gladly, but I'm not. There are people in this country who can speak much more powerfully and effectively to all the things I've talked about than I can. And in a way, it's a symptom of where we've come to, that this critically important issue is not viewed as, perhaps, it's certainly also, but I think primarily as a civil rights matter, is viewed as an educational leadership matter. And I think, if you understand what I'm trying to say, I don't want to be misunderstood here. This is really, really important, but to keep this society on the track that began with Brown, we need to rethink how we're thinking about diversity and what it's connected to. As I put in an op-ed piece in the New York Times after the Fisher case last June, good decision, glad it reaffirmed Gruder, it lacked heart. And that's what we need to make this successful. Thanks very much. I'm happy to take questions again.
President Bollinger, the opposition against affirmative action in some of the major universities, like University of Texas at one time, didn't seem to impede those institutions from recruiting large numbers of African American and Latino athletes. What is the reason given there?
Well, the relationship of sports, college sports, to the issues we're talking about, you raised, is fascinating. And, I think one can see in this both, I've heard this from people over the years, opportunities for getting into the mainstream of America, but also a way of marginalizing people of color, and theme of exploitation, as well as some forms of inclusion and opportunity. I think those kinds of tensions are what I would describe, but I have a feeling you have a wiser answer to this question than I do.
I think, for example, I tried to sell to Julian Bond about 10 years ago when he was chair of the NAACP, the idea that at that time it was University of Texas where they were taking action against affirmative action, to get the scouting reports of the leading high school football and basketball players you could readily pick out the minority athletes, specifically the African American athletes, and try to impress the athlete and the family that they should not sign a letter of intent to go to that university as a mean, because they have many more alternatives. It wasn't like when I was a young man playing football in Western Pennsylvania. The black athlete has many opportunities all over the country for participation. And he wrote me back and said, well, how do you do it? It seems as though our major civil rights organization does not want to move into that arena of trying to influence the black athletes, high school athletes, who have competency in football and basketball, not to sign a letter of intent to go to those universities which are banning affirmative action. For example,
I see.
I think, personally, I think we do not have a collective identity as a people, even though the struggle that we've gone through. For example, I cannot imagine a competent high school basketball player signing a letter of intent to go to the University of Kentucky or the University of Louisville, as long as their senator in that state, O'Connell, takes the position that he does in the Senate of the United States. And take Alabama, for example. University of Alabama in Auburn, football is God. The budget of the University of Alabama's football team is $128 million a year. If you could get the outstanding high school black athletes not to sign a letter of intent to go to those two universities, it would have some political impact.
That's
Thank you.
very interesting.
I'd like to raise a hopeful counter to the situation you described, using the Posse program, which is 25 years old, as an example. This is where small groups of underrepresented students are sent to universities, started by Deb Bial in 1989, I believe, at Vanderbilt. They have graduated almost 5,000 students in these 25 years, and the retention rate is 90%. Which is astonishing. I don't know of any other single group that is that high. And the University of Rochester will be taking its first Posse group next fall. So we're looking forward to seeing how that works out. That's a small step of civil rights, at least in education, and shows that your background does not determine how you will do at a good school.
Thank you.
Dear President Bollinger, I just want to ask a question about in the educational issue. So lately, there has been debate in, especially in Chinese American community, about the SCA number 5. I'm not sure if you have heard of it. It's called Senate Constitutional Amendment, which is try to abandon the previous. In 1996, in California, they passed the 209 to try to not consider race and gender in education system, but now they try to revise that to consider race, especially that affect Asian Americans, it's like Chinese American community. They try to restrict the ratio of like public educational system, like college settings. And you mentioned in UC Irvine, you against they considering enrollment based on their race and their ethnic background. I'm wondering, what are you thinking about this issue? Thank you.
Yes, I mean, thank you for raising it, and I know about this. I mean, I am in favor of affirmative action. I understand that some people and some groups view that as a zero-sum game. That is, if you can consider race and ethnicity in admissions in order to get a diverse student body that is racially, ethnically mixed, that will mean that some people who would get in without that policy will not get in. I mean, that's true. I mean, the work by Bill Bowen, former president of Princeton, who was also president of the Mellon Foundation, wrote a very, very good book about this, making the point that people vastly overstate the degree to which their application will be adversely affected by an affirmative action policy. I mean, it's just the numbers are just not there. But it's a profound feeling, and at some level there is a reality to it. My view is that that's a cost for a policy that's worth doing for the society. I often give the reference to George Washington, the early kind of founders of the country that said, we need in our universities to take into account geographic consideration. We need to get kids from all over the country, all over the colonies and the new states, in order to get them together so they know each other, because they're going to have to work together as a country. And if you start to build up these prejudices that come from just not knowing people, but you think people from this state, are dumb, or they're loud, or whatever the stereotype is, that will hurt the country. I mean, we need, in that system, when you go for geographic diversity, or you go for global diversity, or you go for different kinds of talents, yes, some people will end up getting in over others. Every admissions office will say, we are in the process every year of composing a group of students who reflect all kinds of interesting differences. And I think that's the way we want it, and I think people support it, and it just, when it comes to race and ethnicity, that people begin to back away. And I say, first of all, I don't think that's fair, because you've got to see that the rest of the student body is also put together by taking into account different, I mean, we do not take 800 SATs and then draw a line. I mean, you got all kinds of people who have different qualifications who were turned down. If you believe in the benefits of diversity for the society, given all the reasons I've given, other people could give, that's worth the cost to some people of not being able to get in who otherwise would. Just like it's worth the benefits of having people from Oregon part of a school and not all people from New York City. Joel?
Lee referred to the need for a new civil rights movement, and I infer it would be one that focused on race. And you referred to the UCLA study, which really refers to the new form of segregation.
With class and,
But
yeah.
I would put it in terms of either de facto or residential. It is segregation which crosses jurisdictional lines for school systems.
I see.
For account.
Yeah.
And it's a different issue than, in some sense, was looked at by Brown. It's an issue the Supreme Court said they couldn't address in earlier cases. I know you said you shouldn't be the leader of this movement, but if you might want to offer some incipient reflections, how do we address whether it's the issues of class or the issues of if you will, jurisdictional residential segregation? That's one we don't seem to be doing very well with.
Yeah. Well, I mean, those are really important, obviously very important questions. I mean, I still am of the view that the issues of race in America are not only about low income. I still think that, I mean, you had Claude Steele, my good friend, your good friend, come last year, was it? And, Claude makes the case as well or better than anybody I know that to be of a certain skin color in a society, just like being of a certain body shape or but in this case, skin color. No matter your wealth, no matter your standing and so on, you live a different life. And that's something every society, especially this one, should want to work on. So I think the problems go beyond low income and inner city and so on, but they are very significantly also inner city and residential patterns and school financing systems. And I've looked into we all know that the inequality of income has become a big theme. Globalization is blamed for it. The people I know who really study this and people here who study it, I think would say it's a piece of it. We went for a global system in the 1980s and 90s without having corresponding policies for how to address the dislocations that would bring to people. Joe Stiglitz makes that point very powerfully. Certain people benefit from policies of globalization. We all benefit in this room. Other people in the society don't, but what are we doing to try to address that? The educational system has to be changed to affect this. We have very hard time changing our educational system. I would certainly be in favor of a major social effort. I mean, I would love it if President Obama would say, it is time in America that we really address in a comprehensive way the problems of our public school, our K through 12 system, including questions of financing, questions of organization, geographic limits of control, as well as it's so politically fraught that it's going to take somebody who's prepared to really challenge the system and take the consequences. I think taking on the healthcare, I think this is the equivalent of taking on the healthcare. And I wish he would do this. But I think these can only be addressed by massive social policies. You and I both know, in 1975, the Supreme Court, by one vote, I think it was 75 or 76, in the San Antonio case, by one vote, decided that a property tax system for financing public school education was constitutional. Had it gone 5-4 the other way and said a child's opportunity for education, which should be a fundamental right in the 14th Amendment, cannot turn on the wealth, the property values of a district, which 4 justices were prepared to hold. Would that have significantly changed I know there have been lots and lots of movements to try to address this and litigation under state constitutions and, a lot. But we're facing, it seems to me that would have been a big difference. It seems to me we are facing a time when it's going to take movements of some dimension to really change the political system, which is, we know, in a state of gridlock, so that it takes on these big things. The Occupy Wall Street movement, I think, was not successful, and I think made some points, and I think it addressed some issues. I'm not endorsing it or not endorsing it, but I don't think that has the core of the issues in hand. Part of it, maybe we're just at the beginning of something here. So I can't say But when you think of what was achieved through the 1950s and 60s, especially in the things we're talking about now and trying to hold on to, I mean, right now it's sort of like a rear guard action. We're trying to keep what is so good. I mean, those were powerful changes in American society, and it looks to me like we need more citizen action around these things. I think young people, I mean, this is very much sort of where this has to come from. I really am privileged to one more? Okay.
Yeah, my question is probably a little broader, but I've been doing diversity and inclusion work for over 20 years, and I've gone to a couple hundred gatherings like this at least, and I always see one great frustration, and that is, where are the white guys? And when you're trying to implement the kinds of changes that you're talking about, or policies, trying to shift the culture in your school, how do you do it when the only people that show up to gatherings like this aren't like me? That's maybe a rhetorical question, I'm not sure.
Well, I think, I actually think there are a lot of people in the room, but I think that I think there is a need for many people to speak out about this. That's why I've devoted myself to doing it, but I have felt from the time I got involved in the Michigan cases that it was quite striking how hard it was to get people to organize and speak and join in and the like. But this is all this very big and very hard to talk about in a meaningful way, citizen action and the like, and that's sort of where I would like to see things happen, but I don't know how to do it exactly. Anyway, let me close by saying, Vivian, Joel, your community, thank you very much for having me today. Thanks, Joel. Yeah.
That was terrific. Thank you. I'm so glad.
Yeah,
That was
Vivian,